Hi, this is Alan Gassman, and welcome to our webinar entitled Creditor Protection for the Single Physician. If the sound is a problem and you're listening on the computer, then you can call in. There are instructions for call-in. If you need those instructions, just let us know. I'm going to talk until approximately 6:15 on what individuals need to know about protecting their assets from creditors. I'm going to follow the PowerPoint pages, and also you have some other enclosures that you're able to download if you like. One is a checklist that you're going to see on the PowerPoint pages. A couple of them are articles that we've written on the biggest mistakes that physicians make with respect to medical practice management, investments, and creditor protection. And the last item is a multiple-page outline, in fact, a 48-page outline on Florida creditor protection for physicians. I'm going to follow the PowerPoint, so you really won't need to look at anything other than the PowerPoint here. And my red dot can help show you where I am on the PowerPoint. The page you're looking at now, which is the second page of the PowerPoint, gives you some webinar information on how to access this webinar later if you want to view it again, and also calling in if you have issues concerning the sound. My next slide is simply the well-known saying, it wasn't raining when Noah built the ark. It's always better to get this planning done well before the floods and not after. The following, page 4, some nice quotations. There's always Murphy's Law. Anything that can go wrong will go wrong. One of our jobs as a estate planning lawyer is to try to think through what may possibly go wrong and how to handle it. Secondly, from F. Lee Bailey, anyone who acts as his own lawyer has a fool for a client. We do a lot of estate planning for lawyers who know that it's best to go to somebody who knows the small area as opposed to trying to take your best guess on what to do for this type of planning. The next slogan, perfectionists don't always win. A lot of the techniques I'm going to talk about here would not be successful 100% of the time, but maybe would not be successful 100% of the time if it went all the way to a final trial, but can be very successful in deterring creditors from ever trying to go that far. Finally, the Robert A. Heinlein quote, don't handicap your children by making their lives easier. That goes to the fact that most single people should have good estate planning documents to protect their children, often from themselves. Now, page 5 is a partial checklist that you might want to use for your own planning. And I've got columns for whether this item is finished or whether it needs to be done, whether you're not sure, and who you would delegate making sure it's been done. And a few things that we may not mention during the presentation that are on the checklist. Number 1, malpractice insurance and a possible corporate malpractice insurance policy. I always am a little bit chagrined when we do a creditor protection plan for somebody and then they tell me, good, I'm going to drop all my insurances. Well, I would keep the insurances up. That's one of the reasons that somebody will settle a lawsuit is if you have an insurance policy protecting you and providing a legal defense for your matter. Umbrella liability insurance. If you're driving a car or using real estate, you definitely want to have a policy going well over $1 million and not just have a $250,000 or $500,000 car insurance or property insurance, casualty insurance policy. Making sure that your IRAs are properly managed, also your pension plan, and then other things that we will cover during the seminar, except the last one, and that is making sure that you have a team of qualified and caring advisors, which will normally include a good CPA, investment advisors, a lawyer like me if it's estate planning, or who can refer you to good subspecialist lawyers if you need other items, and liability insurance agencies. Okay, introduction, page 6. This is hard stuff, so we try to do it carefully. Page 7, here's your cheat sheet. You could print this out and carry it with you wherever you go. Just for the purposes of drilling into memory, these are the creditor-exempt assets, which creditors have a really hard time getting hold of. Would be homestead, up to half an acre within the city limits, IRAs, 401k and pension plans, which you should be maximizing, the cash value of life insurance policies, if properly owned, annuity contracts, which we'll review more later, wages and wage accounts, and 529 plans that are college savings plans that you can put away and designate for somebody's college. These are the assets that, if you own them before there's a problem, you may be able to file a bankruptcy, and get rid of any and all debt without having to lose any of these assets. That assumes that your debt would be from a lawsuit over a medical practice or a business activity, and not personal debt like personal credit cards or personal loans. Those may have to be repaid over time. But if you could keep all your assets in the creditor-exempt category, then you would be able to tell creditors, sorry, there's nothing here you can take. So you'll have to settle for my limits of coverage. And that will normally work. Now, there are other assets that are not exempt per se, but which are very difficult for a creditor to get into and will usually deter creditor action. These would be limited partnership interests, which we'll talk more about in a little while, foreign trusts and companies, foreign bank accounts, which I normally don't recommend, but they are a little bit hard for a creditor to get hold of. And then, as I said, I rarely recommend the foreign entities, but sometimes we do. And we'll talk about asset protection trusts as well in this presentation. Then the assets that are absolutely exposed to creditors include your individual money, your brokerage accounts, your individually owned real estate, other than protected homestead, and even your personal assets. I would mention at this point that beyond this chart, there is also protection of assets by having a friendly creditor. If a creditor has a lien on the things that would otherwise be exposed, then another creditor can't take those assets unless they pay the friendly creditor. So for some of you, we have done some friendly creditor planning. I'll also mention that these 529 plans can be a very good investment, even if you don't necessarily have anyone imminently ready to go to college. You can set up a 529 plan in the name of a nephew, for the purpose of benefiting a nephew or a niece or a grandchild, and you can later use the money completely for yourself with no need to account to the beneficiary, and you can even change the beneficiary completely once a year, and there's no tax unless and until you pull the money out. If you eventually pull the money out to help someone with college expenses, then there's no tax on the gain. All right, page 8, some definitions. If I can teach you the language, you can understand how this works. There's the debtor who owes money, the creditor who is owed money, the judgment. You don't have to pay someone normally unless and until they have a judgment against you. So once you know they're going to sue you, they can't come and get your assets. Once they sue you, they can't come and get your assets, except on very rare occasion. They have to go all the way through trial and get a judgment against you before anyone can be ordered to turn over your assets. And as you know, that can take years. There's the plaintiff who files the lawsuit. There's the defendant, who's hopefully not you, but that's the person being sued. There are exempt assets. I'll be using the word exempt assets. These are assets that under the Florida statutes or federal law, a creditor can't touch, like a homestead, annuity, life insurance that we were showing on the prior screen. And then there's non-exempt assets. These are the assets that a creditor can take, like a bank account or furniture and equipment. Okay, Section 8. On page 9, there's the concept of a fraudulent transfer. That's a really bad-sounding word, but it doesn't mean committing fraud or misleading somebody. It means taking a non-exempt asset and moving it to an exempt status or transferring an asset so that a creditor can't take it. And if you do that for the primary purpose of avoiding a creditor, then it may be set aside. Under Florida, there's a 4-year statute. Now, sometimes people will still commit protective transfers, and they may even end up in bankruptcy. If you end up in bankruptcy within 1 year of doing what we call a fraudulent transfer, then you could lose your right to go bankrupt. But otherwise, you simply have the risk that the transfer you make may be set aside. It's not always a bad idea to make a protective transfer. Although you may hear at a cocktail party or from a non-specialist lawyer that it's a really bad thing to make a fraudulent transfer, it may be a really worse thing to leave an exposed asset in your own name when a lawsuit's heading your way. So that's something that careful and appropriate counseling is an important part of. Then there's the concept of a preferential transfer. If you take money out of a company that's going to go bankrupt within a certain period of time, that might be set aside. It's just something to know about. There's the concept of bankruptcy on page 10, where you have the right to file a Chapter 7 bankruptcy and to discharge creditors. The creditors go away, and some of your assets may go away. But it's a process that is available because America does not put people in jail when they can't pay their debts. It just makes them go through a Chapter 7 bankruptcy sometime. There are payment plan bankruptcies called Chapter 11 and Chapter 13 bankruptcies that very few people will ever have to go through. Page 11, there's the concept of joint and several liability, where you may not do anything wrong, but if you're the partner of somebody who does something wrong, or you're the employer of somebody who does something wrong, then you may be sued, even though you did nothing. There is the concept of a secured interest on Section 15. If you have a mortgage against my rental home and somebody else sues me and gets a judgment, you get paid before they do. And a mortgage is a secured interest on real estate. The same concept works for personal assets like furniture and equipment. If you borrow money from your father-in-law, then you could give your father-in-law a secured interest lien on the assets, and then another creditor would have to pay your father-in-law before they could take the assets away. Now, Section 17, the charging order. The charging order is a concept whereby if you own an interest in, for example, a limited partnership, if you're a 70% limited partner in a limited partnership, somebody else is a 30% partner, and I get a judgment against you, I cannot take your 70% partnership interest away. What I get is a charging order. The court orders you and the partnership to give me your share of any distributions, but there is nothing under the law that requires the partnership to make distributions. So I would rather have my assets in a limited partnership where a creditor can't reach in, as opposed to having my assets in my personal name where a creditor can reach them. And we'll talk a little bit more about charging order protection later on, but that's just one of the definitions to try to get used to using. Okay, 18 is firewall protection. If I own a business directly in my name and somebody sues the business, then they sue me, and I'm responsible for the debts of the business, even if somebody breaks their neck on something that I really maybe shouldn't have known about. But on the other hand, if I put that business or that rental property under a limited liability company or a limited liability limited partnership mechanism, then the creditor can only take the assets of the entity and not all my personal assets, which is why I have many clients who may have, for example, 15 rental buildings, and we may have them in 5, 10, or even 15 separate limited liability companies or limited liability limited partnerships or other types of entities. Number 19, the concept of limited partnerships. There's something, just so you know, there's something called a limited liability partnership that doesn't provide much protection, whereas there's something called a limited liability limited partnership that does provide protection. So you have to be careful. Make sure you're using a lawyer who knows the differences between these types of entities. Section 20 is an asset protection trust. Most clients have revocable trusts, which may protect you from probate and guardianship, but will not protect your assets. If you put assets into a trust that you can revoke, Or under Florida law, if you put assets in an irrevocable Florida trust that allows the trustee to make payments back to you, then the creditor can basically reach what you're allowed to reach, and it doesn't do much good. But there are jurisdictions, notably including Delaware, Rhode Island, Alaska, recently Nevada, the Cook Islands, Belize, Nevis, that allow you to set up a trust, put your assets in the trust, give the trustee the authority to spend the money on you or to use the assets for your benefit, and notwithstanding that, by the law of the offshore or the out-of-state jurisdiction, creditors can't reach into the trust. And we call that an asset protection trust. They are not well tested in the court system. United States courts don't like them much, but they will stand up under many circumstances, and they are difficult for a creditor to break through. Depending upon circumstances, however, I will note that if you try to set up an asset protection trust or a charging order protection type situation at the last minute, it may still be broken apart by a court based on the fraudulent transfer statute. For people being sued for malpractice, which unfortunately happens quite often and often to the best doctors, there's a concept of bad faith I want you to know about. If an insurance carrier is defending you on a claim and they have the chance to settle it within policy limits, then if you will ask them and in fact demand that they settle within policy limits and they don't, then any excess verdict is their responsibility and not yours under most circumstances. So often the lawyer representing you who is being paid by the insurance company may nudge you to have what's called a bad faith letter written, or may not want to get the insurance carrier upset with them by suggesting it. So you may want to talk to your private lawyer about any malpractice actions or other lawsuits against you to try to get the bad faith letter written if and when it's time to write that. When we start writing those letters, we find that cases get settled more quickly, and I can tell you more about how that happens if we ever have another webinar on that, on defending malpractice actions, which we eventually will. Automobile liability, I just wanted to remind you that you're responsible for liability incurred by anyone driving a car owned by you in Florida, unless the driver has at least $500,000 coverage and you have not been, and except if you have been negligent in trusting the vehicle and letting them drive it, then you may still have liability. So we want to be careful on car driving and ownership. Okay, page 15. I have a typical single physician here. And what do they own? Well, they have an IRA account. You should certainly maximize your IRA contributions. They're creditor proof. 401k pension account. If you don't have many employees, there may be some really good ideas on how you can maximize your pension, even beyond what you're doing now if you talk to a pension actuary. If you've never had an actuary check to see what's available to you, then you might want to do that. Annuity contracts are also creditor proof. We'll talk a little bit more about them in a little while, and they're significantly detailed in the 48-page outline. Life insurance contracts, which can be expensive because of the administrative and sales charges that are imposed on them, but they're also creditor proof. And then wages in a wage account. So those are things, and then if you would move the wages from the wage account to another exempt asset, they are going to be creditor proof. The automobile is typically not creditor proof. A lot of clients will put a 48-month loan on a car or a lease on the car. Creditors, I've never seen a creditor who wanted to take over a leased car or a car that had a loan on it that was almost the amount of the value of the car. And then the homestead, up to half an acre within the city limits, up to 160 acres if you live outside of the city limits, and no matter what the value of the home is, you have a creditor exemption for homestead. Then many clients have a revocable living trust for estate planning purposes to avoid probate and guardianship. That won't help with creditor protection at all. But they may also establish an irrevocable trust for their children, and the living trust or the person individually and the irrevocable trust for the children may own a limited partnership. And if the client owns a 97% ownership interest in the partnership, and the irrevocable trust owns 3%, and somebody gets a judgment against the client, then under the Florida statutes, they should only be able to get a charging order against the partnership, which makes it very difficult for them to reach into the partnership. Now, once they get the charging order, it's not possible to pay money from the partnership back to the client, but the creditor can't force any money to be paid, so there is usually a favorable settlement when that occurs. Now, some clients don't like the idea of having a charging order against them, so what do? Well, if the client really likes their brokerage accounts, they don't have a lot of good alternatives. One alternative would be to sell the brokerage accounts and buy variable annuity contracts. You can go to a life insurance company, they'll take your money, they'll put it in an account, and then they will allow you to get the money if and when you want it. But when you pull the money out, you'll pay an ordinary income tax on the appreciation in value. That's deferred until you take it out, but also if you take it out before you're 59 and a half, you'll pay an extra small tax on the income in the contract. Still, a good number of clients do own variable annuity contracts. You can buy them even from Vanguard, where Vanguard charges, I think, less than 0.5% plus the cost of the mutual funds within them. And it wouldn't be a bad idea to have some assets in variable annuities as opposed to having everything in brokerage accounts under a limited partnership. Now, some clients would have this partnership owned 3% by the client and 97% by an asset protection trust. This could be a Belize, Nevis, Cook Islands Asset Protection Trust. By the law of the Cook Islands, it would not be subject to creditor claims. The question is whether a Florida judge would decide that Florida law should apply. Since the client lives in Florida, the assets might be in a Merrill Lynch brokerage account.
Welcome to GoToWebinar Welcome to GoToWebinar Web Events Made Easy.
There are court decisions where judges have been visibly upset at debtors who put things offshore at the last minute. But we don't have any good cases showing that if you do this well in advance, there won't be a problem. The reason for that is apparently that creditors settle for nickels or dimes on the dollar when you've done this creditor protection planning well in advance. So this client may have taken real estate and placed the real estate in separate LLCs for each property, and then have the LLCs owned by a limited partnership, and then have the limited partnership owned partly by a creditor protection trust, which may be offshore or might be in Alaska. Now, for this particular client, if you have S corporation stock and you want it under an asset protection trust, you could not put it in a foreign offshore trust because you would lose your S election. So that might be an Alaska asset protection trust. On the left-hand side, you've got a wage account where the professional practice pays wages. The wage account might then be reinvested within 6 months, is the rule, into variable annuities or 401ks or into the limited partnerships. And then you may have a building company, an LLC perhaps, owned partly by the gifting trust with a long-term note, or a long-term lease where the professional company is paying the building LLC rent. And there may be mechanisms set up under the building mortgage and under the lease which help to keep creditors from finding the professional practice entity from being an attractive target. Okay, page 16, a little bit more detail on the mechanisms we've discussed. On the homestead, we used to tell clients to not worry about last-minute transfers into the homestead. The Florida Constitution says that the homestead exemption trumps the fraudulent transfer statute. So somebody could have a judgment against me on Monday, and before the sheriff comes to get my things on Tuesday, I could sell them, pay down the homestead mortgage, and there's nothing the creditor can do. Unfortunately, if I do that, then under the new Bankruptcy Act that was passed in 2008, if I end up in bankruptcy, the money I put into my homestead at the last minute may be set aside if I bankrupt within 10 years of making the fraudulent transfer. So we do have a few clients who are never going to be able to go bankrupt, or we're going to have to wait at least 10 years before they can ever go bankrupt, and in the meantime have judgments against them. And we find that the creditors will normally settle and are not going to want to wait for years to see if they can penetrate a homestead. Also, you have to be a Florida resident 730 days to protect your home under Florida law. If you end up in bankruptcy, you have to have the property for at least 1,215 days, although you can roll it into another property, and there are other exceptions that apply. One notable exception is that if you break the law and owe somebody because of a white-collar crime, then your homestead exemption may be denied in bankruptcy. Or if you acted maliciously or with criminal intent or recklessly and willfully, you may lose your homestead protection if you end up in bankruptcy. Some people have more than half an acre of homestead. So for those clients, we may have half an acre under the client's name and the remaining property under a separate entity that they may use. Now, page 21, pensions and IRAs, it's just important to do them right. Most clients will have a CPA or an actuary firm administer the plan, make sure it's done correctly. If you don't do it correctly, then it may not be protected. With an IRA, you don't really want an IRA to own any real estate or other assets that you also are involved with, or that could disqualify the IRA. Now, there is a bankruptcy law which says that only $1,095,000 of IRA is protected in bankruptcy, but IRAs that are funded from rollovers from 401k and pension are not subject to that limitation. So that would just be the little IRA that you started funding many years ago at $2,000 a year. I doubt that that's up to $1,095,000. Now, with annuity contracts, the owner of the contract is the protected person. So if I'm going to invest in an annuity contract, I want to make sure I'm the owner, not my revocable trust, not another trust, but me individually. With life insurance, the same thing applies. The life insurance needs to be on my life, and it needs to be owned by me individually. If it's owned by me, but it's on the life of one of my children or my ex-spouse, that is not creditor protected. Now, with the life insurance and the annuities and the IRAs, you want to be very careful as a parent or uncle or aunt as to who inherits these when you die, because these pensions, IRAs, and life insurance contracts pass by beneficiary designation. And if your will or trust says that you want all your assets to be held under a long-term trust for your children, and the life insurance contract or the annuity contract says that you have it going to your estate or directly to the children, then that's the way it's going to pass, notwithstanding what is in their best interest. And then creditors may be able to reach it once the children get it. So, and as a matter of fact, if you leave life insurance to a child and the child's being sued the year that they inherit it, then it is accessible to creditor claims. So what you can do is make your life insurance, annuity, and IRAs payable to trusts that benefit your relatives or your loved ones without being subject to creditor claims of your relatives and loved ones. And that's something to check in your estate planning. Now, there's also something called a grantor retained annuity trust, which can be used to really reduce federal estate tax. And this can also, incidentally, protect assets from creditors. Personal property, your furniture, your equipment, your dog. This is exempt only up to $4,000 in value. Fortunately, though, the value is normally done by garage sale valuation, and many people, don't realize that a lot of the things you have may not be worth all that much. But if it's a concern, and if you owe anyone money, you can give them a lien on your personal assets, and then it's hard to get hold of them. some clients will put collectible assets into creditor protected limited partnerships or LLCs. More on wages. Now, the good news is that the Florida statute says that the head of household can receive an unlimited amount of wages, and that this is an exempt asset that can then be saved in an annuity or homestead or another form. And when you receive the paycheck, even when somebody's suing you, it should not be considered a fraudulent transfer to assign the paycheck or endorse the paycheck into another protected mode. Unfortunately, though, some courts have said that where the wage earner actually controls the company paying him or her, that they could manipulate whether the money comes out as wages or dividends, and therefore the wages are not protected. Now, these court decisions are not all well written, and some of the scholars think that if you have a proper arm's length written employment agreement specifying a weekly, biweekly, or monthly wage, and you actually pay that wage and it's a reasonable amount, that the wages should be creditor proof. So many clients will have a fairly simple but explicit employment agreement to help document the wage amount. And if you're taking money out of your professional company, partly as wages and partly as dividends on the advice of your accountant, then you would typically want to save the wages in another exempt asset and live on the dividends. Now, there's also this concept of the wage account, and the wage account is a Florida statute creation, which says if you put your wages in a bank account, they're protected for up to 6 months. Some clients will set up a wage account and protect and then move the assets to an exempt investment every 6 months. I favor not waiting 6 months. I'm concerned that people may forget, and we see that people will often forget to sweep their wages into wage accounts. Now, the limited partnership and the limited liability company and the charging order concept that I was referring to, we have been under the impression, as I believe was the Florida legislature, that limited liability companies had equal charging order protection to limited partnerships and have been using them accordingly. An exception to this would be a single member LLC. If I own 100% of an LLC, then a creditor might be able to break into it under some court cases which basically say that the purpose of the charging order is to protect other owners from having the disruption of an entity that they've invested in by the creditor of another owner. So it would be best to have a multiple member LLC and to have at least one of the members not have a judgment against them, not have the same creditor coming after them. Well, the Florida Supreme Court recently issued a decision in a case called Sean Olmstead, where there was a single member LLC, and the person had allegedly done some very bad things, and the government was mad at them and wanted to invade their LLC. And the Supreme Court, and I talk about the decision on page 32 of the PowerPoint, the Supreme Court said that a single member LLC is not protected, and also said that they don't think that charging order is the sole remedy that a creditor can pursue with a limited liability company. They, I believe, were quite confused about the legislative history and why and when the legislature passed the law on charging orders, and seem to have come to the conclusion that a charging order is only one of the remedies that a creditor can use. Now, there are already efforts by legislative committees to revise the Florida statutes to make it absolutely clear that charging order is the sole remedy for a limited liability member's creditor. And in the meantime, I'm sure that we're going to have court cases probably going both ways on whether the Supreme Court is correct, because the Supreme Court holding doesn't necessarily apply to multiple member LLCs. So in the meantime, there are a few things that can be done. LLCs can be converted to limited partnerships, And then you would have the limited partnership protection, which is more explicit in the statute, and which the Florida Supreme Court actually blessed in their decision. Another thing that married couples can do is hold LLCs as tenancy by the entireties, but I wanted to make sure I mentioned that single people can't have tenancy by the entireties. That's one disadvantage of not being married. Also, depending upon the operating agreement of the limited liability company, even if charging order protection is not the only remedy, somebody foreclosing or taking ownership of an LLC interest may not have the ability to vote the interest or to act as a substitute owner. It's still going to be difficult to break into multiple member LLCs. Having restrictive stock certificates may also be useful. So there may be some LLCs that will be restructured. My best guess is that the legislature is going to legislatively make clear the charging order protection, but it's going to be sometime in 2011, and it may explicitly require that there be other substantial members besides the debtor. Now, at page 35, I mentioned using debt, and especially for medical practices, often the client will borrow a lot of money on a building or a number of buildings and then give the bank a lien not only on the building but also on the medical practice assets. And that would be one method of a single physician owning a medical practice to help protect the medical practice. A little bit more about asset protection trusts. These trusts, if established in Alaska, Delaware, and Nevada, will be subject to 2 or 4 year look-back statutes, and you will need a co-trustee or a trustee who is in the state where you form it. And like I said, there are more states than Alaska, Nevada, and Delaware, but those are 3 of the better-known states that have some pretty good legislation. The question is whether the full faith and credit clause of the United States Constitution would allow Alaska law to apply when you have a Florida resident, or whether an upset judge might say that Florida law should apply. And then what do you do when an Alaska trust company is ordered to turn something over by a Florida judge? It's going to be an expensive mess. On the other hand, if you use Belize law, for example, Belize has a statute that says that the look-back period is 1 day. As long as you didn't have a judgment against you in Belize on the day that you set the trust up, the trust company is not, the trust is not subject to claims. Also, as a practical matter, if the assets are in an offshore jurisdiction, how is a U.S. judgment going to require the trust company to turn money over? If the trust company is in one of the countries that don't acknowledge U.S. judgments or which require a completely separate independent jury trial to get a verdict, then the creditors are really going to have a hard time going there. Nevis, for example, requires a creditor to have a separate trial in Nevis, does not allow lawyers to work on a contingency fee basis, and requires a $12,500 US deposit into the courthouse in Belize to even file an action against a trust. Page 37, we spoke about firewall protection. Page 38, please don't drop your liability insurances. You'll still need defense counsel. You'll probably still have some exposed assets. You'll sleep a lot better if you have plenty of liability insurance. And finally, with 3 minutes remaining, page 39, for those of you who have a medical practice entity, some ideas on how to pull money out of the entity. Usually the entity is an S corporation. You can have a pension plan and fund the pension plan. That's probably the best thing you can do. Are your children working there and you put them on the payroll? They may be at a lower tax rate, and also they may be able to set up Roth IRAs that will be protected for them if they have the income. Wages are going to be protected, but they are going to be subject to the wage taxes. Dividends will typically not be protected if you own the medical practice individually, but maybe a family limited partnership or similar entity might own the medical practice and receive dividends. Although with an S corporation, the ownership has to be individuals or usually qualified trusts. Spouse on the payroll, well, you're single, so that's not going to help you. Rent, which would be paid to a family limited partnership or similar entity, will be subject to sales tax but not wage taxes, and could go into a family limited partnership or other protected entity. And then interest, if the S corporation borrows money from a related entity, it could pay interest at a fairly high rate. That's going to be tax deductible, and the money's going to be owed to the other entity, and the other entity might have a lien on the practice. So obviously, I hope I've given you a lot to think about. I would say that creditor protection for an individual with a number of assets in different situations is quite a bit an art as opposed to just a science. Not every client walks out of our office with the same plan based upon what the client thinks about different things, what the risk factors are, what the costs are to set up and maintain this type of thing. But it wasn't raining when Noah built the ark, so you really want to be set up well in advance and not at the last minute. Okay, let me open up to just a couple of questions here. We do have some pretty good questions. Let me see. The first question is, how can I protect my future inheritance? That's a very good one because I didn't mention that. But one of your possible assets could be a future inheritance, and you definitely want to have your parents not leave assets directly to you. In fact, if they die within 6 months after you go bankrupt, you still lose the inheritance. But they can leave the assets to a trust, and under Florida law, you can be the trustee of the trust. You can have the right to control the investments. You can have the right to get whatever you need for health, education, and maintenance to maintain your standard of living, but the trust will be creditor-proof, and no one can make you take the money out of the trust. So that would be a good creditor protection mechanism. Secondly, is it better to have a limited partnership or an LLC established in Florida or some other state? Well, Florida has huge filing fees and annual report fees for limited partnerships. It's $1,000 to file one and $500 a year to maintain it, just by paying just what you owe the state of Florida. Whereas Colorado is under $100, is about $100 to form it, and under $300 a year, even with a registered agent there. Colorado is probably just as good as Florida law for a single person. Wyoming is good, Delaware is good, so different clients will use different states. Now, some lawyers believe that they can move a Florida limited liability company to Delaware or Texas or some of the other states and have charging order protection, even if the Supreme Court view on that turns out to be right. I'm just not so sure that Florida law will or won't apply to determine whether there's charging order protection for an entity formed in another state where it's managed from Florida, owned by a Floridian and owns Florida assets. And then the last question is, what if you have everything protected for being single, but you get married? Then what happens? Well, then everything should be just as well protected once you're married. You would also have the opportunity to have tenancy by the entirety's assets, where you can place things in joint names, and then they have to have a judgment against both spouses to get them. And you can have a prenuptial agreement to protect your other assets, and those will generally hold up pretty well. So, of course, the single client is typically asking about getting married, and the married client is typically asking about getting single. The important thing is to be happy and to keep your estate planning lawyer busy. And with that, I'll close down the seminar. I'm very available to take emails at agassman, A-G-A-S-S-M-A-N, at gassmanpa.com. I've enjoyed chatting with you, and I hope you've enjoyed listening. Thanks very much for the opportunity to provide this information to you, and have a great evening. Good night.